All right, welcome to this high-octane explainer on the comprehensive rules of civil liability. I am absolutely thrilled to guide you through the fascinating, complex, and honestly vital world of the law of torts. We're going to break down the exact mechanics of your legal rights, the wrongs that can be committed against you, and the specific remedies the law provides when things go sideways. If you want to really understand the invisible legal armor that you are wearing every single day, well, you're in exactly the right place. Let's get into it.
So, here's our roadmap for today's masterclass. First, the foundation of civil wrongs. 2, defenses and expanding liability. 3, torts against person and property. 4, reputation, negligence, and remedies. And finally, 5, the modern consumer's shield.
Starting right at the beginning with Unit 1, the foundation of civil wrongs. Before we demand a fix, we gotta define the found.
Let's dive right into this core distinction. What exactly is a tort? Basically, a tort is a private civil wrong that is entirely independent of a contract. When someone commits a tort against you, your remedy is a claim for unliquidated damages. Now, that's a crucial legal term. It literally means the damages aren't pre-agreed upon in some document. The court actually assesses the financial hit based on the specific facts of your injury. Contrast that with a crime, which is a public wrong punished by the state, or a contract where you have fixed duties and liquidated or pre-agreed damages. A tort is all about the court fixing a wrong that the law itself says just shouldn't have happened to you.
Okay, let's look at a classic 1-2 punch of legal maxims. First up, damnum sine injuria, which means damage without legal injury. Way back in 1410, in the Gloucester Grammar School case, a schoolmaster lost a ton of money because a rival set up shop right nearby, and the court basically said, too bad, it's fair competition. See, financial loss without a violated legal right? Not a tort. Now flip that around. Look at injuria sine damno, legal injury without actual damage. In 1703, in Ashby versus White, a man was wrongfully denied his right to vote. His preferred candidate ended up winning anyway, so he suffered literally zero practical or financial loss. But the court still ruled in his favor. Why? Because his legal right was violated. The law is there to vindicate rights, not just to compensate your financial losses.
Moving right along to Unit 2, defenses and expanding liability. When a wrong happens, who actually takes the fall?
Listen, if you're going to remember just one defense today, make it this one. Volenti non fit injuria. It translates to the voluntary assumption of risk. And the rule here is incredibly simple but totally unforgiving. If you willingly step into a danger zone with free, full consent and you know the risks, you cannot cry foul later. You consented to the risk, which entirely wipes out the defendant's liability. I mean, think about it. You literally can't sue someone for giving you a black eye if you voluntarily stepped into a boxing ring with them, right? Now here's where things get interesting. Liability isn't always restricted to the guy who actually did the deed. We're looking at a high-density breakdown of how liability shifts. First, vicarious liability. In Limpus v. London General, an employer was held liable when their bus driver decided to race another bus and crashed. Even though the boss explicitly forbade racing, the driver was still technically doing his job, just in a really unauthorized way. So the boss pays. Next, state liability. Can you actually sue the government? Yes. In state of Rajasthan v. Vidyawati, a government jeep hit a pedestrian. The court said the state is totally liable because driving a jeep isn't a core sovereign function, it's just regular driving. And finally, the constitutional tort. In the tragic Nilabadi Behera case, a death in police custody, resulting in the Supreme Court holding the state strictly liable to compensate the mother. The state absolutely cannot hide behind sovereign immunity when fundamental constitutional rights are violated. And this brings us to a brilliant illustration of how liability for dangerous activities has evolved. On one hand, we have the old 19th century English rule of strict liability from Rylance v. Fletcher. If you bring something incredibly dangerous onto your land, like a massive reservoir of water, and it escapes and floods your neighbor's mine, you are strictly liable. But back then, you still had a few defenses, like blaming an act of God. Now, contrast that with India's massive, aggressive modern upgrade, absolute liability. This was established in M.C. Mehta v. Union of India after a terrifying oleum gas leak. The Supreme Court laid down the law declaring that hazardous industries operating for profit owe an absolute, non-delegable duty to society. If harm happens, they pay. Zero exceptions, zero excuses, literally no defenses apply.
Let's shift our focus to Unit 3, torts against person and property, the visceral, everyday violations.
Let's talk about false imprisonment. This is defined as the unlawful, total restraint of someone's freedom of movement. We aren't just talking about locking someone in a closet. It is a total deprivation of liberty.
You really need to consider the gravity of the Rudul Saw case here. This man was acquitted, cleared of charges, yet kept in prison for 14 years of illegal detention. The Supreme Court didn't just order his release, they mandated heavy compensation under Article 32 of the Constitution. It proved once and for all that false imprisonment isn't merely some private tort between two citizens, it can be a massive constitutional violation that triggers huge public law compensation from the state itself.
Moving from the physical body over to property, we run into private nuisance. This is the unlawful interference with a person's use or enjoyment of their land. I want you to look at the everyday reality of Arati Sham v. Gur Prasad. The defendant set up this incredibly noisy, vibrating flour mill right next door to the plaintiff's residential home. The court stepped in and granted an injunction to shut it down. Why? Because even if running a flour mill is a perfectly lawful, legitimate business, doing it in a residential neighborhood and completely ruining your neighbor's peace and sleep, that's an unreasonable interference. Your right to run a business ends exactly where your neighbor's right to peace begins.
Okay, let's break down the actual math of compensation in fatal motor accidents, specifically looking at the Supreme Court's strategy in the landmark Sarla Verma case involving a DTC bus crash. To calculate what they called just compensation, the court created a really strict formula. Step 1, you deduct 1/3 of the deceased's income for their own personal living expenses. Step 2, take that remaining dependency figure and multiply it by a specific number based on the deceased's age. Step 3, you add a percentage for future prospects, which acknowledges that realistically the person would have earned more money over time. It's a highly precise, strategic calculation designed to ensure fair and uniform compensation across the board.
Stepping into the modern battlegrounds now. Unit 4, Reputation, Negligence, and Remedies. Let's talk about your good name. Defamation is the publication of a false statement that lowers your reputation in the eyes of right-thinking members of society. And guys, the stakes here are incredibly high. In Ram Jethmalani v. Swamy, some wild accusations were thrown around in a press conference claiming the plaintiff had received money from terrorists. The court came down hard, ruling this was highly actionable defamation. The key takeaway for us? The defense of justification or truth completely failed because the defendant just could not prove the allegations were actually true. Bottom line, if you throw false, reputation-destroying accusations in public without bulletproof evidence, the law of torts is going to make you pay for it.
Now this right here is perhaps the single most famous quote in all of tort law. Delivered by Lord Atkin in 1932, you must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. This comes from the legendary case Donahue v. Stevenson. Mrs. Donahue found a decomposed snail in her opaque ginger beer bottle and got terribly sick. Now, she didn't buy the beer, her friend did, so she had zero contract with the manufacturer. But the House of Lords ruled that the manufacturer still owed her a duty of care because she was the foreseeable end user. That one single decomposed snail literally birthed the entire modern law of negligence and product liability.
Let's see how that duty of care builds into a highly sensitive area, medical negligence. We have to clearly separate a civil mistake from a criminal act, and we use the Jacoby-Matthew case to do it. For civil medical negligence, courts use the Balam test. Basically, did the doctor act in accordance with a practice accepted by a responsible body of medical opinion? If yes, then there's no negligence, even if something tragic went wrong. But for criminal negligence to attach, the standard is way higher. The negligence must be gross and culpable. It can't just be a simple error in judgment. The Supreme Court purposely set this high bar to ensure doctors aren't absolutely terrified of criminal prosecution for every single medical complication.
So, you've been wronged. What are your weapons to actually fix it? Well, you've got two arsenals. First, judicial remedies. These are granted by a court. The most common is compensatory damages, getting money to make you whole, or injunctions, which are powerful court orders demanding someone stop doing something. But then you have extrajudicial remedies. This is raw, legally permitted self-help. You can lawfully use reasonable force to physically expel a trespasser from your land. You can even use something called distress damage feasant, which is a fancy way of saying if your neighbor's cattle wander onto your property and eat your crops, you can legally detain those animals until the neighbor pays up for the damage.
And finally, bringing this explainer into the 21st century. Unit 5, the modern consumer's shield.
The 2019 upgrade to consumer law in India gave it incredible, aggressive new bite. It created an absolute powerhouse of a watchdog, the Central Consumer Protection Authority, or CCPA. These guys have the power to initiate class action lawsuits, order global recalls of defective products, and issue massive fines. The act also modernized your access to justice by enabling the e-filing of complaints, and crucially, it heavily targets false advertising, slapping huge fines not just on the shady manufacturers, but directly on the celebrities who endorse those misleading products.
And as a consumer today, you are armed with 6 unshakable statutory rights. Rapid fire, here they are. You have the right to protection against hazardous goods, the right to full information on quality, purity, and price, the right to access a variety of goods at competitive prices, the right to be heard at appropriate forums, the right to seek redressal against any unfair trade practices, and finally, the right to consumer education. This list isn't just nice theory, it is literally your impenetrable shield against corporate exploitation.
Let's apply this shield to a real-world, albeit tragic, situation. The Act strictly penalizes any deficiency in service, which basically means any inadequacy in performance. In the heartbreaking Spring Meadows Hospital case, a nurse administered an overdose of medicine to a child, which sadly caused permanent brain damage. The Supreme Court definitively ruled that medical care provided for a fee is a service under the Consumer Protection Act. Therefore, hospitals and doctors are fully, entirely liable for deficient services before consumer commissions. Medical care is fundamentally a consumer service. So, if you actually need to fight a consumer battle, where do you go? The law maps out a 3-tiered battlefield based entirely on pecuniary jurisdiction, which just means the amount of money at stake. If your claim is up to 50 lakh rupees, you file right at the District Consumer Commission. If the stakes are higher, anywhere between 50 lakhs and 2 crores, you escalate directly to the State Consumer Commission. And for those massive claims above 2 crores, you bypass the lower tiers and head straight to the National Commission, the NCDRC in Delhi. You know exactly where your lawsuit belongs, based strictly on the value of the wrong committed against you. We've really journeyed today, haven't we? From a 15th century schoolmaster losing money, all the way to 21st century laws punishing misleading celebrity ads. We've seen courts mandate compensation for absolute liability, for medical negligence, and for false imprisonment. So I want to leave you with this final provocative thought to ponder. As liability aggressively expands from those ancient common law torts to strict modern consumer protection, are your everyday rights infinitely more protected than you ever realized? Just think about the massive, invisible legal armor you carry every single time you step out your door. Thank you so much for joining me on this explainer. Stay curious and stay informed.